Good afternoon, everyone. Thank you very much for being here today for this first online event of the HeiParisMax-Partnership. So my name is Guillaume Futazard. I'm a senior research fellow at the Max-Planck-Institut in Heidelberg, and today I will be your host. Today, the event will be recorded and live streamed, but only the presentations, not the Q&A session. So as soon as it's going to start live streaming soon, but it will only be the speakers recorded. So your face will not appear on the live stream, and only the presentations will be recorded. The Q&A sessions will be completely non-recorded. So at this point, we'll be able to discuss more freely. So before we start this event, I would like to thank you, the representatives of the HeiParisMax-Partnership who are here today. So on the Parisian side, I would like to welcome Professor Lagrange from University Paris 1 Panthéon-Sorbonne, and also Professor Régis Bismuth from the Law School of Sciences Po. On the German side, I would like to welcome Professor Ute Haager from the Law Faculty of the University of Heidelberg, and finally, Professor Anne Peters, Director at the Max-Planck-Institut for Comparative Public Law and International Law. So before we start the presentations, I would like to give the floor to Professor Lagrange and Professor Haager, who will give a short presentation of the HeiParisMax initiatives and what it is all about. Professor Lagrange, Professor Haager, you have the floor.
Merci beaucoup. Bonjour à tous. Je suis très heureuse et très honorée de dire quelques mots de présentation de HeiParisMax, je prononce à l'allemande, un partenariat académique franco-allemand et donc à ce titre un partenariat trilingue, allemand, français, anglais, parce que c'est une langue de travail pour tous également. Il a été créé sous une forme très souple entre l'Institut Max-Planck de Heidelberg, l'Université de Heidelberg, l'Université Paris 1 Panthéon-Sorbonne et l'Institut d'études politiques de Paris, également connu sous le nom de Sciences Po Paris, pour encourager, faciliter, soutenir le croisement de perspectives franco-allemandes sur un système juridique global en transformation. Ces perspectives sont d'abord celles de juristes en droit international, en droit européen, en droit comparé, mais ce peuvent être aussi celles d'autres représentants de sciences sociales et humaines au-delà du droit. L'objectif de ce partenariat est de favoriser la mobilité, je le précise tout de suite, sans programme spécifique de financement, et les échanges d'idées de part et d'autre de la frontière. Now, I would like to sum up the presentation in English. HeiParisMax is a French-German partnership aiming at facilitating, encouraging, and upholding mobility and dialogue on researches in progress or just completed in international, European, and comparative law, with a focus on a changing global legal system. This is a trilingual program, and it was initiated by the Max-Planck-Institut of Heidelberg, the University of Heidelberg, the University of Paris 1 Panthéon-Sorbonne, and Sciences Po Paris. It's worth saying that there is no specific mobility grant attached to this partnership. I hope you will enjoy this first online session, and I give the floor to Ute Haager.
Ja, herzlich willkommen. Ich freue mich, Ihnen diese Partnerschaft in deutscher Sprache jetzt noch einmal vorstellen zu dürfen. Es handelt sich um eine institutionelle Partnerschaft zwischen der Universität Paris 1, Panthéon-Sorbonne, auf der französischen Seite sowie auch dem Institut d'études politiques de Paris und auf der deutschen Seite von der Universität Heidelberg, der Juristischen Fakultät der Universität Heidelberg und dem Max-Planck-Institut für ausländisches öffentliches Recht und Völkerrecht. Die Idee dahinter ist es, die deutsche und französische Perspektive auf das globale Rechtsgefüge im Wandel zum Gegenstand zu machen. Und es geht dabei insbesondere und zunächst um das öffentliche Recht, aber auch um das private internationale Recht, also das öffentliche und private internationale Recht. Es geht um das Europarecht und die Rechtsvergleichung. Ziel dieser Partnerschaft ist es, den Austausch zu fördern, die Mobilität zu fördern, zwischen den Forschungseinrichtungen, aber auch solche Veranstaltungen, wie wir sie jetzt haben, durchzuführen. Ein wesentliches Element, wie schon gesagt, besteht in der Mobilität von Wissenschaftlern, insbesondere Professoren, Doktoranden, promovierten Nachwuchswissenschaftlern. Und in dem Sinne kann man sagen, ist es eine schöne Ergänzung zum Erasmus-Programm und füllt gewissermaßen diese Lücke, die besteht, oder ist eine Ergänzung dazu. Ja, vielen Dank.
Thank you very much, Professor Lagrange. Thank you very much, Professor Marge. Now we can turn to the heart of this meeting, and we will begin by a presentation by Professor Anne Peters. Professor Anne Peters is director at the Max-Planck-Institut for Comparative Public Law and International Law and specializes in many branches. Today, we have the pleasure of having a short summary of the lesson she gave at the Hague Academy for International Law. She will discuss the question of animals in international law and give us some very interesting insights on this hot topic in international law. Professor Peters, you now have the floor.
Merci beaucoup. So let's start with COVID-19, although we're all sick of it. COVID-19 is, as meanwhile everyone knows, a zoonosis. It's now almost certain that it originated from a wild animal market in Wuhan, and not from the bad laboratory next to the market. In any case, COVID-19 has come upon us as a result of human use and abuse of animals. This zoonotic pandemic can only be addressed by relying on a global law approach, which takes into account the shared vulnerability of human animals and other animals. A vulnerability which is a globalized condition. As some of you might know, that in the more than 30 mink farms in the Netherlands and in Denmark, a mink-human transmission of COVID-19 took place. In the Netherlands, Parliament adopted a law prohibiting the business, coupled with the financial compensation of the fur farmers. Denmark only suspended the business. In both countries, more than 23 million of the animals were culled. So indeed, the vulnerability is shared, but power and the means to exercise deadly force remain unequally distributed among humans and animals, also in times of COVID-19. Let's look at some basic facts. The by far biggest group of animals are animals in agriculture. 450 billion land animals are confined for food at every moment each year. And an estimated 58 billion land animals are slaughtered worldwide, and about the same number of sea animals. In comparison, only 126 to 150 million animals are used worldwide for research. 80% are rodents, such as mice. So the number of animals used for food is 4,000 to 5,000 times bigger than the animals used for research. Wildlife is only a tiny mass. Only 3% of the Earth's biomass, of the terrestrial biomass of animals, are wild animals. Against this background, it's interesting to see that there are three, I would say, pillars of animal-related laws. And among these various types of laws, on the various levels, national, regional, and international level, we can distinguish first species conservation regimes, and current international Hague treaties are the only type of law which exist in this first pillar. And this concerns, of course, only a very small subset of animals under conservation treaties. In contrast, the welfare of individual animals or possible rights of some animals is not yet specifically addressed by international law. The international rules on the welfare of the animals, as one animal as a good of its own, not only concerning the good of a group, such rules are almost completely lacking. on the international level. So far, animal welfare, the second pillar, is addressed only in international soft law and only very rarely in an ancillary fashion in the conservation regimes. The third pillar, animal rights, legal entitlements for animals which protect their fundamental interests against encroachment, as opposed to merely benefiting animals and their quality as objects of protective rules. Such entitlements have so far only been recognized in some court decisions, for example, in Argentina, Colombia, India, and Pakistan, but not in international law. To sum up, animal welfare and animal rights are so far addressed almost exclusively on the national level and not in international hard law proper. Current animal welfare or anti-cruelty statutes mostly date from the second half of the 20th century. Currently, 101 states of 195 states of the world, so roughly half of the states of the world, possess some kind of animal protection legislation. There is a website built by an NGO, which is called Animal Protection Index, which I saw you on the slide. And this protection index classifies 50 countries around the world into 6 categories, scoring from A to F, according to their commitments to protect animals and to improve animal welfare in policy and legislation. The classification looks not only at the law in the books, but also at the law in action. And in this ranking, Switzerland and Austria are in the best performing group of states. Germany scores lower, the United States of America scores even worse, and China is in the second lowest class. Russia is in the worst group, to mention only some important states. Europe is the world region with, relatively speaking, the best protection for animals. All member states of the Council of Europe possess animal welfare laws. Asia, except Japan, is the region with the least protection for animals. So what has been protected here traditionally? The German philosopher Immanuel Kant in 1797 in his Metaphysics of Morals wrote about the dulling of shared feeling, which would be a problem for humans when they treat animals badly. On the slide, you see a famous 4-table illustration by William Hogarth, the 4 stages of cruelty. You see in the upper left corner, boys molesting animals. In the right corner, you see that these boys are grown up, young men who molest bigger animals like horse and sheep. Then comes the 3rd stage, namely that one of those boys, as a grown-up, has killed a woman. So the 3rd stage of cruelty. In the 4th slide, in the right bottom corner, you see that this murderer had been executed and he is in an anatomic class. He is under vivisection, and the dog, or a dog who had been molested, is eating his intestines. That was a very popular picture set which illustrated and which sought to educate people about the dangers of cruelty against animals. Of course, a completely anthropocentric approach. In our current situation, we have animal issues as a globalized problem, which requires a global solution. Even if we stick to this purely anthropocentric rationale, it compels a global approach. Because in our globalized world, virtually all aspects of the commodified human-animal interactions possess a transboundary dimension. I'll give you some examples. Meat, dairy, leather, wool, and all other animal-derived products are made in global supply chains. Moreover, the consumption worldwide is rising due to a growing demand of consumers in developing states. And as you know, animal food is extremely resource-intensive. According to the Food and Agriculture Organization, 26% of the terrestrial surface is used for grazing animals. And this causes, of course, enormous erosion, which you see on the left slide. European animals need so much more fodder that can be grown in Europe that animal fodder, for example, soybeans, needs to be imported from Latin America. 80% of the entire world's soybeans productions are fed to animals. The food production is being globalized, and livestock, and in smaller numbers pets, are transported across countries and shipped overseas. And they are here exposed to extreme risks. On the slide, you see a scene from 2019 when the cargo ship Queen Hind capsized in the Black Sea off the Romanian coast. More than 14,000 sheep drowned. Other globalized issues are, of course, global warming, which is mainly induced by the abundance of cattle waste and which strikes the whole planet. Wars are fueled by wildlife poaching, and so on. I could go on with these examples. Another aspect is, of course, that the developing states, which have copied the industrial animal production methods of the rich states, often hardly apply animal welfare protection standards. And even those states which have high domestic standards for animal welfare, such as Germany or France, cannot always implement these standards in full. Why? Because international trade law requires uniform standards and may prohibit a state from banning cruel production methods unilaterally. Importantly, the threat that the relevant industries, food and pharmaceutical companies, will move to production sites with low animal welfare standards, this threat pressures the lawmakers and risks to trigger a stagnation of standards, in the extreme case even a race to the bottom. And for all these reasons, the welfare of animals is a global issue that requires a global response. This means that the regulation of animal issues must transcend national boundaries, and here we face a huge gap of regulation and a gap in research. The transboundary dimension of one single aspect of human-animal interaction had already been recognized in the 1920s. On the slide, you see a window in the halls of the World Organization for Animal Health, the Office International des Epizooties, founded in 1924 with its seat in Paris. This international organization was founded for fear of the spread of diseases to humans, so for fear of zoonosis like COVID-19. It has extended its mandate since 2002 to cover not only animal health, but also animal welfare. However, the standard this organization adopts are extremely low, and there is also, I would say, some capture of the organization by the pharmaceutical and agricultural industries. Nevertheless, I think that it's possible to develop the OIE to an institutional hub for a global animal law. When I say global law, I mean law transcending all levels: international, regional, national, and local, public and private law, including soft law. 9 states have since the 1970s adopted clauses on animal welfare or prohibitions of cruelty, even in their constitutions. Most famous and far-reaching is the Swiss Federal Constitution of 1999, which even speaks about the dignity of living beings. Other countries which have constitutional provisions are in chronological order: India, Brazil, Slovenia, Luxembourg, Germany, Ecuador, Austria, and Egypt. The question is, of course, what's the added value of such a constitutional provision? Roughly speaking, when something is put in the constitution, it has offers stronger legal protection and offers higher protection to animals when their welfare is balanced against conflicting values or conflicting legal goods. For example, when it comes to a conflict between animal welfare and the freedom of religion, as in the case of religious slaughter. Actually, a case in Germany on Muslim halal slaughter in the 1990s was the trigger for the German constitutional provision on the state obligation to protect animals. In this case of Muslim slaughter, animal welfare had to recede against the freedom of religion, because at that time, when the first case happened, only freedom of religion was protected in the Constitution, but not animal welfare. And this decision, which went out in favor of the religious slaughter without stunning the animal, then triggered a constitutional reform, which happened in 2002 and inserted an obligation of the German state to protect animals in the Constitution. The classic rationale of all these provisions, and also typically of animal welfare statutes, are the ethics of guardianship or stewardship of humans over animals, and a utilitarian ethics of minimizing animal suffering. The classic source is the English philosopher, utilitarian philosopher Jeremy Bentham, who wrote a famous footnote in a book, which I put in full on the slides. Bentham wrote, "Slaves have been treated by the law upon the same footing as in England, for example, the animals are still." But Bentham projected that the day may come when the rest of the animal creation may acquire those rights which could never have been withholden from them but by the hand of tyranny. Some have already discovered the blackness of the skin is no reason why a human being should be abandoned without redress to the caprice of a tormentor. It may come one day to be recognized that the number of legs, the velocity of the skin, or the termination of the os sacrum are reasons equally insufficient for abandoning a sensitive being to the same fate. The question is not, can they reason, nor can they talk, but can they suffer? End of quote, Bentham. This utilitarian ethics is matched by the legal qualification of animals as things. In the domestic laws of most countries, this is a category inherited from Roman private law, which drew a fundamental distinction between persons and things. Persons or subjects can be holders of rights, whereas things or objects can by definition not have rights. Most importantly, things can be possessed by persons as property. Animals have been legally coded into property, and it is this legal coding which turns the animal, a living being, into capital and gives it the capacity to generate wealth for its owner. Animals as things can, in law, only be the beneficiaries of protective rules. Such protective rules establish standards of protection and may create duties for the addressees, but they do not generate rights for the beneficiaries. I can explain the difference between being the object of protection on the one side and being the holder of a right on the other side with the example of the Mona Lisa in the Louvre. It is prohibited to scribble upon Mona Lisa, but Mona Lisa has no right to be scribbled upon. She cannot have such a right because she's a thing, a painting. In the past decades, the civil law codes of several states have modified the traditional legal status of animals in two variations. The historically first variant is the purely negative statement that animals are not things. Such a pronouncement was first made by Austria in 1988, followed by a number of countries. In these countries, which comprises Germany, the new legal statute, not thing, did not in itself change the applicable rules. Despite their removal of animals from the category of things, the legal rules on things still remain applicable, either directly or by analogy, as the mentioned provisions in the civil code books say. And in this scheme, the animal's legal advantage of being not things remains unclear. A progressive legal variant is the positive qualification of animals as sentient beings. This was introduced by the European Union, and it is now also in the French Civil Code. The reform of 2015 recognizes that all animals are êtres vivants doués de sensibilité, living creatures endowed with senses. Portugal and Colombia also adopted that formula. So the question is now, what follows from this new legal label as sentient beings? I think that the new legal term sentient beings opens the way for overcoming the Roman law-based dichotomy between things and persons. I think that it should be understood as a new and intermediate legal category which stands between persons and things. But in the end, what matters is not the statutes but the legal rules that apply. The civil codes of the Czech Republic and Portugal go one step further by stating that the legal rules on things are applicable to animals, and this is important, only to the extent that these are compatible with the animal's nature and their legal status as sentient beings. I think that this makes a difference. I can give you an example. The example of separately selling a chimpanzee mother and her baby chimpanzee to different research laboratories, which is common practice, of course. This is legal when the chimpanzees are regarded solely as things. But I think that its lawfulness becomes doubtful when the chimpanzees are regarded as not things. And when the chimpanzees are qualified as sentient beings, provided that sentience is properly understood to encompass also the mental well-being, then I think that we would have to come to the conclusion that such a transaction must be prohibited, because of course the separation of a mother from her young infant would cause severe emotional distress and mental anguish in those individuals. To conclude, the recent trend to remove the animals from the category of things does not in itself improve their legal protection. Tangible and clear legal effects result only from an explicit statement that animal sentience forms a legal limit to subjecting animals to the regime of things. In contrast to the legislation just mentioned, rights for animals have been brought about so far only by strategic litigation. But there is always the question of competences of courts as opposed to parliaments. For example, in this lawsuit decided by the US District Court for the Northern District of California in the Naruto case, the question was about Naruto's, who is on the picture, copyright about this on the selfie, which he himself took. An NGO tried to reclaim Naruto's intellectual property rights. However, the court said that Naruto is not an author within the meaning of the Copyright Act. Because the argument by the NGO was, says the court, an argument that should be made to Congress and to the president and not to the court. So the judge said that it is impossible to create a right for Naruto without a statutory amendment by parliament. In contrast, in Argentina, a lower court in 2016 did not shy away from developing the law. The case was about the chimpanzee Cecilia, around 30 years old, and after the death of her two companions, she was completely alone in a concrete cave without shelter. The judge, a female, Maria Alejandro Mauricio, issued a path-breaking judgment. She wrote, "To classify animals as things is not a correct standard. Animals are sentient beings." She also says that protection against animal cruelty and animal preservation are not enough. Based on various criteria, notably the genetic proximity of great apes and humans, and a host of biological and social and cultural features of primates, the Argentinian judge recognized that, I quote the judgment, "Primates are non-human legal persons and they possess fundamental rights." So the court declared Cecilia to be a non-human legal person. The judge also found that the habeas corpus procedure was the applicable proper procedure. The result of the case was that Cecilia was transferred to a sanctuary in Brazil. Follow-up questions to this case are, of course, which other animals need rights? Only great apes or also others? then which rights do they need? I would say that Cecilia does not need a right to religious freedom, for example. She simply does not need it, just like a man does not need a right to abortion. And maybe the law should not grant a right to life to a mosquito if it doesn't feel pain. Apparently, our sensitivity on animal issues has much grown. But how reliable is it as a moral compass? Is the quest for strict animal protection or even animal rights, is that not a civilizing mission of the West over the rest of the world, inattentive to local culture? A recurring normative objection against intensified animal protection law with a potentially global scope is the reproach of cultural imperialism. On the slide, you see the example of San Francisco's live dog market. On this market, you could buy dog for meat. But in 1990, the slaughter in public in San Francisco's Chinatown markets was prohibited. So the question is it not hypocritical, given that billions of pigs, which are at least as sentient and capable of experience as dogs, are slaughtered for consumption by Westerners? The only distinction to the San Francisco dog market is that the slaughter of the pigs is carefully hidden from the public. And what will a devout Hindu think who takes a look at our cattle slaughterhouses? Another example is the indigenous seal hunt. The import of seal products has been banned by the European Union because the European consumers don't like it. Their moral feelings are offended. But animal protection measures, such as the ban on the import of seal products, are criticized on the ground that animal protection and the animal rights movement, like the human rights movement before it, are yet another crusade by the West against the practices of the rest of the world, and that the propagators of such crusades claim universal validity in order to impose their own purely local preferences on other cultures, in order to consolidate cultural and also political dominance over the non-Western world, especially over the global South. I think that this charge is not entirely absurd or trivial. There is a real risk that the protection of animals targets minority practices, such as Muslim ritual slaughter or the indigenous seal and whale hunting. These practices are in numerical terms really small in comparison to the majority's normal massive use and killing of animals. This targeting manifests and fuels majority prejudices against the minority groups, and it can pave the way for intervention and domination. In fact, dominant groups have long justified their exercise of power over minorities or indigenous peoples by appealing to the backward or barbaric way they treat women, children, or animals. And the Inuit on the poster against the European seal products ban criticize exactly that. Save the baby veal and avoid cultural prejudice, in a nice pun, I think. Along these lines of cultural sensitivity, the Treaty of Lisbon on the European Union, which entered into force in 2009, contains a new animal welfare mainstreaming clause, but with a reservation for religious rights, for cultural traditions and regional heritage. You see the text on the slide. It's not surprising that this reservation was included in the treaty text upon lobbying by Spanish diplomats. And a recent Spanish law has legally defined bullfighting as part of the cultural heritage of Spain. However, we need to draw a line between legitimate concerns of cultural diversity and the abusive invocation of culture by those aiming to secure illegitimate privileges. And this line is not easy to draw. In this area of tension, I would like to make 3 points. First, I think we should not exaggerate cultural difference. After all, a common feature of almost all cultures of the world is their massive and taken for granted use of animals for human needs. And the commonality is the lack of any attempt to justify these practices in ethical terms. Second, more importantly, cultures do not unfold immutably as if according to a genetically defined pattern. For example, eating shark soup made of fins cut off live sharks, or eating the flesh of cows which have been improperly stunned in a European slaughterhouse. This may be a tradition, just like relegating women to the house and prohibiting them from exercising certain professions, or prohibiting women from driving a car, which was only recently abolished in Saudi Arabia. But simply because these are traditions, they are not inevitable and they are not worthy protecting as such. Third point, there is the problem of double standards. This is what the Inuit poster's message is. Stop teaching us about seals while you kill veal. But the proper remedy against hypocrisy is not stopping to criticize abhorrent abuses elsewhere, but rather to terminate one's own abuses too. In other words, double standards should be terminated by leveling up, not by leveling down. The Californian political scientist Claire Jean Kim, in her book Dangerous Crossings, has convincingly argued against the minority's defense that the majority, or the West, is hypocritical. She has argued as followed. I quote her: "The implication here is that the majority should leave minorities alone until the majorities clean up their own house. In other words, minorities' disadvantages earn them a place at the end of the reform queue. However, unjust disadvantages in one sphere does not earn unjust advantages in another. Having endured racism and colonialism, subjects deserve justice and reparation from their oppressors, but they do not deserve to dominate women, animals, and nature." End of quote, Kim. In other words, suffering from cultural and political oppression is no excuse for making other, still weaker members of society suffer in turn. To conclude, cultural diversity is no blank check for animal abuse. Instead, morals, traditions, and legal provisions are made, practiced, and applied by human beings capable of learning and can be changed. For example, an ECJ judgment of this March from the European Court of the European Union, the court issued a judgment on the abhorrent practice of glue trapping birds to use them as decoy birds. On the slide, you see a trapped bird sticking by the glue. Upon request for a preliminary ruling by the French Conseil d'État, the Court of the European Union had to interpret the EU directive on the conservation of wild birds. The direction prohibits glue trapping, but it allows member states to derogate from the prohibition where there is no other satisfactory solution. For the reason, for example, that it's not possible to capture certain birds in small numbers. The French ministries are regularly allowing to glue trap birds for the hunting season in certain French departments, notably in the Alps. But the ministries allowing this only say there is no other satisfactory solution. The European Court of Justice now interpreted the Birds Directive in light of Article 13, the animal welfare mainstreaming clause I mentioned on the other slide, and said that simply asserting that there is no alternative to glue trapping is not enough. The traditional character of this hunt in itself is not enough to allow France to authorize glue trapping. Let's go back to COVID. A new scientific paradigm is the One Health approach, dramatically brought to the fore by COVID-19. This approach is defined in a recent United Nations Environmental Programme publication as the collaborative effort across multiple disciplines for preventing and managing diseases occurring at the interface of human, animal, and environmental health. A One Health approach is necessary facing the ongoing human-induced explosion of zoonoses. According to the Intergovernmental Platform on Biodiversity and Ecosystems Services, an estimated 1.7 million currently undiscovered viruses are thought to exist in mammal and avian hosts. And of these, 450,000 to 850,000 viruses could have the ability to infect humans. As The Lancet pointed out, new zoonotic diseases are emerging and are re-emerging at an exponentially increasing rate. Not all zoonoses become pandemics, but most pandemics are caused by zoonoses, and they have become the characteristic of the Anthropocene era. The reasons are land use extraction, the clearing of land for farming and grazing, the intensive industrialized livestock farming, and increased human encroachment into wildlife habitats. Also, deforestation frees microbes, many of which have not yet been encountered by people. The United Nations Environmental Programme sums this up as follows, I quote, "Pandemics, such as the COVID-19 outbreak, are a predictable and predicted outcome of how people source and grow food, trade and consume animals, and alter environments. A solutions scan published by a Cambridge-led international team of wildlife and veterinary experts in June 2020 gives a list of options for reducing the risk of another pandemic. The team mentions, among others, the following: reduce animal density both within and between farms. The group finally mentions also the options to promote the development and commercialization of synthetic alternatives, synthetic fur, leather, or laboratory-created meat, and to influence consumer attitudes in order to increase the acceptability of low-risk substitute products, plants and synthetic substitutes for food, clothing, and medicine, instead of using animal products. These are the suggestions of a Cambridge-led team. To sum up, COVID-19, including the episode of the mink culling, demonstrates that One Health must take not only wildlife but also livestock more decisively into its purview. COVID-19 illustrates how the law has up to now been and will probably always be profoundly ambivalent about animals. The mink culling exhibits how the law entrenches structural violence against animals by allowing and protecting enterprises such as zoos and fur farms, mainly for the sake of economic profit of the humans running this business. In order to protect human health from a modest risk, 23 million minks were lawfully killed without any consideration for the value of their lives for them. A modified and strengthened One Health approach might bolster an initiative to prohibit mink farming altogether, even on a global scale. What is needed, for the reasons I mentioned, is a global approach. The question is, of course, is such a new thinking possible? On the slide, you see a zoo poster of the Basel Zoo, which advertised the soon-to-be extinct lip Negroes. This poster of 1926 advertised a common practice, which went on as late as 1985, so only 80 years ago, the exhibitions were stopped. The Völkerschauen, for example, in the Basel Zoo. See how our attitudes have changed? And I think that it is possible to drive change also today. This talk was based on my book, which was published just last week. Thank you very much.
Thank you very much, Professor Peters, for this talk. I will now give the floor to Denys-Sacha Robin, who will be the discussant for this session. I will just ask some of the participants now to maybe turn off the camera so we are sure that we have a good internet connection for his presentation. So if some of you could just turn off the camera to make sure the internet is stable. Okay, thank you very much for that. Now Denis has started sharing his slide and I give the floor. Of course, an introduction would be best. So Denys-Sacha Robin is maitre de conférences at Nanterre University, and he was previously a PhD student from Paris 1. So we are staying within the context of the HeiParisMax-Partnership. So now, Denys-Sacha, you have the floor.
Thank you, Guillaume. Do you hear me well? Okay, thank you. Well, I'm really sorry because I like to apologize first because it is the first time that Zoom is telling me that my connection is too weak. So I'm really sorry about that. It always happens and when we most need it, of course. Well, I would like to thank all the professors and all the people involved in this partnership for inviting me. It's been a few years, the doctrine of international law and even the French one has accomplished its animal term. In this context, and as a person interested in the scientific study of animal law, I must say that the 400 pages course published by Anne Peters is an important milestone. It really gathers an enormous amount of precise data which are useful for anyone interested in the topic. I would like to start this discussion with an image of the Suez Canal blocked by the cargo vessel Ever Given. As a consequence, as you might know, around 20 livestock ships were stuck inside or near the Suez Canal during almost a week. It represented roughly 200,000 animals, mostly sheep and cows. The cargo vessels were coming from Spain and Romania and going to Middle East countries. The events shed light on the quite unknown situation of live export ships. Firstly, we learned, of course, that the trip is not a relaxing cruise for animals. They are packed, as you can see on the slide, they are packed with the minimum amount of food and water to survive the trip. And even if the Council Regulation number 1, 2005 on the protection of animals during transport applies, a text that explicitly mentions livestock vessels, it seems there is some kind of loophole. A report of the European Commission published in April 2020, last year, a report on the welfare of animals transported by sea, noted that the systems in place in EU member states to approve livestock vessels and to inspect them before each loading are insufficient to minimize the risks. The report noted that the staff was not qualified and that, of course, it lacked enough resources. Secondly, we have learned that thousands of animals transported by sea have died during the last few years. Some of them died because of the poor conditions during the trip. Others have been slaughtered at their arrival because of delays and sanitary risks. In 2019, for instance, a ship full of cows stayed 3 months at sea with no right to disembark the cows, and they were killed at their arrival because of the sanitary risk. Well, this kind of event gives us a good illustration of how animal law, as Anne just exposed, has become a global question. As we can see, farm animals are here literally trapped utilitarian. The case of farm animals, of course, we don't really have time to mention details, but we can mention the fact that African forest elephant, an iconic species, has been listed a few days ago as critically endangered by the IUCN due to massive poaching. The population of African forest elephant fell by more than 85% in the last 30 years, and it is only one recent example in a sad context of mass extinction. In such a context, I am sure we can all agree that the treatment of animals is a global issue and calls for some global answers. What I want to discuss today is the fact that the study of animal law at a global scale illustrates or reveals the interacting forces or tendencies at work in the international society. These tendencies are sometimes complementary and sometimes contradictory. The first one concerns global versus local tendencies. As we have seen, animal law has become a global issue for various reasons, mostly economic. Global issues concerning the treatment of animals have raised awareness about the need for improving animal welfare. In that sense, various facts suggest that animal welfare is a value that is spreading in the international society. The first one, as you can see on the slide, is that international law has made an animal welfare turn. References to animal welfare exist in many areas. During the last 10 years, the work of the OIE on animal welfare has greatly increased. And member states of the OIE adopted in May 2017 a global strategy for promoting animal welfare with regional sub-strategies. The work of the OIE surely participates to a progressive diffusion of animal welfare issues and solutions in the international society. Secondly, the question of animal welfare has become a global concern because, as I like to say, also of the increase and convergence of local initiatives. During the past few years, national legal frameworks for animals have evolved. For instance, after giving the status of sentient beings in 2015 to animals, the French Parliament is now discussing a prohibition of wild animals in circus shows. And as you can see on the map reproduced on the slide, there are more and more countries with color, and the color means more legislation concerning animal welfare. From this perspective, national unilateralism can be seen as complementary to international issues and solutions. More unilateralism also means less chance for economic relocations, less race to the bottom, and at the same time, more unilateralism increases the need for international coordination and then hopefully stimulates international cooperation. Thirdly, local initiatives can also be seen as a solution to a global concern. For instance, a return to local farming is often seen as a good way of improving animal welfare. Local farming for local consumers means less transport, less resources, and it goes in general with more space and more diverse or even organic feeding. In France, for instance, the label Bleu Blanc Coeur is dedicated to the promotion of animal health and welfare, human health, and local agriculture. Also in France, another label, Bien-être animal, animal welfare, has been developed for poultry since 2018. And now some supermarket products show a new tag concerning animal welfare, and a good grade means less time of transport. An A means less than 4 hours of transport, which means more local products. And in fact, it entails that international trade of animals is considered contrary to animal welfare standards. In that sense, global and local solutions can be seen as complementary. However, this line of reasoning finds some limits. Other important facts force us to note that animal welfare is neither a primary nor a universal value. The first one is that there is no international regime of hard law concerning animals or animal welfare as such, as Anne Peters mentioned before. Hard law is fragmented both regionally and substantially. As to the OIE standards, they appear to be soft even in substance. Just to give you an example, when you read the standards for farm animals, you realize they often state that many given practices apply if it appears possible and necessary. It means their practical relevance appears limited. The second fact is that animal welfare is not really an issue in developing countries, especially in African and Asian countries. As you can see on the map, gray areas shows countries where no legislation about animal welfare could be found. In this region, there is a lack of public regulation in favor of animal welfare, as Anne also mentioned. Besides, you can learn in Anne Peters' course that international financial institutions are actually promoting the development of industrialized farming in these countries. So to conclude, the global versus local perspective raises the question of the roles of international law. International law can be seen as a tool for the diffusion and for promoting animal welfare as a global concern. However, firstly, it is hard to think that international law can offer more than it has to offer now without a more radical change from policymakers. International law remains fundamentally anthropocentric. Secondly, I am not sure that it should, because there is always a fear that such a value would contribute to a global tension between North and South. Even though it is an important global issue, even for human health and even for the environment, animal welfare should not be seen as another value imposed by developed countries, while they still are the first ones to slaughter billions of animals. So on this matter, I, of course, totally agree with Anne Peters. The second group of tendencies I would like to discuss concerns welfarism versus traditions. They are often presented as two opposite tendencies or two opposite values. Modern welfarism is seen as eager to reduce unnecessary sufferings caused to animals by traditional practices, or it is even eager to make these disappear. And on the other side, traditional practices are often presented as untouchable or set in stone, or even sometimes they are presented as not that harmful for animals. We often hear advocates of bullfighting or hunting with hounds, la chasse à courre, as you can see on the slide. We can often hear from advocates that they deeply respect the animals they chase or kill. Of course, deeply this moral field. As we have seen with Anne's presentation, the appellate body of the WTO considered that the European Union was entitled to ban seal products emanating from traditional hunting because it hurt the public morality of the European Union. And the EU could do so even if millions of farm animals are suffering and killed in slaughterhouses. Another good and recent example is coming from the European Court of Justice case law on religious slaughter. 3 times in 18 months, the court had to deal with religious slaughter and rules that are supposed to reduce animal suffering. The first 2 cases were more about articulating religious beliefs and rules applicable to animal welfare. In the first one, the Liga von Moskin case of May 2018, the court decided that religious slaughter could happen only in approved slaughterhouses. In the second one, the OABA case of February 2019, the court decided that the European certification for organic agriculture, including high standards on animal welfare, could not be attributed to products coming from animals killed according to religious practices without stunning them first. In the third and most recent case, Central Israelitisch Consistory of December 2020, the Court of Justice showed a more radical approach, directly opposing animal welfare and freedom of religion as 2 contradictory values of the Union. In that case, the Flanders region of Belgium adopted in July 2017 a decree imposing stunning for animals before being slaughtered, with no exception for religious slaughter. According to the court, member states are entitled by, as you can see on the slide, Regulation 1099 of 2009 on the protection of animals at the time of killings. They were entitled to adopt stricter rules for ensuring animal welfare, and this possibility covers also religious slaughter. The main argument of the plaintiffs was that imposing stunning of animals was contrary to their freedom of religion. Both Jewish and Islamic rituals require the animal to be drained of as much of its blood as possible. Its death must be due to the bleeding. The plaintiffs fear that stunning would affect the process. But according to the court and the Flemish authorities, a scientific consensus exists on the fact that stunning reduces unnecessary sufferings and has no consequences on the fact that death is due to the bleeding. According to some scientific studies, electronarcosis is a completely reversible and non-lethal method of stunning. Then the court's reasoning implies that the stunning of animal is compatible with religious slaughter. The court could have stopped here, but it did not, and I think it should have stopped here. But the judges decided to explicitly state that animal welfare and religious slaughter are conflicting values. As you can see on the slide, paragraph 77 of that case stated that, like the ECHA, the Charter is a living instrument which must be interpreted in the light of present-day conditions and of the ideas prevailing in democratic states today. Animal welfare as a value to which contemporary democratic societies have attached increasing importance for a number of years may, in the light of changes in society, be taken into account to a greater extent in the context of ritual slaughter. I think that scientific studies offered a good way for articulating animal welfare and religion. The court could have also mentioned that the debate about stunning animals is open within and among religious institutions, and some of them are actually in favor of stunning animals. And that kind of reasoning could have shown that animal welfare and religious slaughter are not purely opposed values. Instead, the court reasoning gives the impression to be founded on an excluding logic. It gives the impression that contemporary democratic societies reject such rituals. And I think this line of reasoning could be dangerous or deserves to be more subtle and more inclusive. So to conclude, welfarism and traditions could sometimes be less contradictory than it seems. Besides, traditions have never been set in stone forever. When promoting animal welfare, we also have to question the potential roles of law. Law could be a tool for progressive promotion of values. It could be a tool for revolutionary changes, or it could be a tool for domination and exclusion. Rules promoting animal welfare are good for animals, humans, and the environment in general. There is no debate about that matter, at least for me. But these rules also have consequences on various categories of people, workers or believers. And I will stop now, but of course we could talk about the prohibition of wild animals in circus, because it also implies this kind of reasoning. It is hard to prohibit wild animals in circus without considering the situation of circus workers. And of course, without considering the situation of wild animals. Now in France, we have 700 wild animals dedicated to circus shows, and there are only 3 adequate refuges that could actually welcome them if they get retired. So the thinking is actually more complicated than just opposing values on animal welfare and traditions. Thank you.
Thank you very much, Denys-Sacha. So this concludes the first part of our HeiParisMax event. So now the live stream will end. We'll